Hello, class. Today we're going over Chapter 2. I'm going to give you just a few minute discussion on the court system. As you're going through Chapters 2, a couple things to focus on is understanding the difference between the state and the federal court system, taking a particular look at the jurisdictional matters as to whether a case would go to court or whether it goes to federal. A really quick cheat guide is federal questions, constitutional issues, or questions of diversity go to federal court. For state courts, we're referring to state matters like property law, divorces, family law. Those types of issues go to state court. There can be some conflicting topics that could go either to state or to federal. Generally speaking, traditionally certain types of cases are normally deferred to federal, and then there are other types of cases that can be deferred to state. All right, and then depending on the state, can make special requests as well as the federal government. Then later on in the chapter, you will talk about as well as the jurisdictional questions of whether federal or state court systems apply. You'll get a little bit into the court procedures. I will post a separate video on court procedures at a later time, but it is covered in the chapter. It's pretty simplistic, so you can review that material, and if you have questions, shoot me an email. And then finally, you will also go over the alternative dispute resolutions. So in cases, there are a couple options. You can go through the typical traditional route, which would be filing a petition, going to court, having a trial in court, and so forth. But for purposes often in business, we're trying to create quick resolutions of matters. So there is an organizational structure that has been accepted by the court as alternative dispute resolutions. Alternative dispute resolutions are areas of the law like arbitration or mediation. It is diverting a case that would typically go to court to another form of resolution. Mediation is the court simply asking the parties to go before a mediator to reach some type of a settlement. And if you can reach a settlement, then the courts would recognize that settlement and abide by it. And if not, you end up back in court. This is to kind of help reduce the caseload. On arbitration, you're usually waiving the right to go to trial, to court. So often this is very useful for businesses because they need to have quick resolution to contractual disputes usually. And so instead of going to court and have a long, lengthy trial that could take a year to 2 years, depending on the type of case it is, and having nothing resolved during that period of time, there's this mechanism that we refer to as arbitration, which is a lot speedier. So it kind of looks like a court where you have a panel of judges, and you can advocate, both sides can advocate their position, but all the rules of evidence, not all the rules, but a significant portion of the rules of evidence and procedural processes get suspended. You have a more relaxed procedure, so cases can get brought before them in a speedier way, and this helps businesses come to some sort of resolution, and so the parties can move on. All right. So that was, I hope that this was useful information as you get started in Chapter 2. Let me know. If you have any questions, shoot me an email. If you'd like for me to focus on any particular topic, shoot me an email, and I'd be glad to discuss those topics in greater detail. All right. Good luck, and look forward to reading your answers. Thank you.